Hello, my name is Jason Perkins. I want to welcome you to another episode in my Georgia Workers' Compensation video series. I'm an attorney that specializes in Georgia workers' compensation law, and I created this video series to provide people who've been hurt at work with information about the rules of Georgia's workers' compensation law and the benefits available to them under it. Today I want to talk to you about light-duty jobs, and specifically I'd like to discuss what happens if you return to a light-duty job and you're not able to do it. Now, it's important to understand that Georgia's workers' compensation law has some specific rules about light-duty job offers that apply in most cases. Those rules are contained in OCGA 34-9-240 and State Board Rule 240. And what those rules discuss is what happens when your employer offers you a light-duty job and you return to work. Now, those rules cover two specific things. One, they cover what happens during a trial return to work period and whether the insurance company has to restart your benefits if you come out of work within a certain period of time. So in a typical situation, someone may have had an injury at work and they're out of work and they're receiving workers' compensation benefits. And then their employer or the workers' compensation insurance company informs them that there's a light-duty job available for them. It may have been approved by their authorized treating physician, or maybe it's just offered to them and they say it's within your doctor's restrictions. In this situation, when the job offer's out there and someone returns to work, then the question is, what happens if that person comes out of work? If that person's been receiving benefits, there's some specific rules under the Rule 240 that I mentioned earlier that say that if you attempt the job for a certain amount of time and then aren't able to do it and come out, that the insurance company usually has to automatically restart your benefits as long as it's within a certain period of time. Basically, you have to attempt the job for at least one day, one full shift, and it can't be more than a certain number of days, more than 15 scheduled work days. In those situations, if you attempt the job and come out within that time, then the insurance company has to restart your check. But it is important to understand that that's not the end of things. The insurance company can still take you to court to try to get your check stopped after they've restarted it. In other words, on a temporary basis, there's a determination that you're still entitled to workers' compensation benefits because you weren't able to continue the light-duty job. But the insurance company, if they want, can still have a chance to prove in court that you can do the light-duty job. And if they're successful, they may be able to stop your workers' compensation benefits, and they may actually be entitled to get an overpayment or credit for the benefits that they paid you during the time the job was available to you and you weren't doing it. So that's one situation as far as what happens when you return to light duty and aren't able to do it. Now, one other thing that you have to be aware of is sometimes people return to a light duty job before they've ever been paid workers' compensation benefits, or they return to a light duty job and they work more than 15 days. Now, in those situations, it can be much different. The insurance company may not have to automatically restart your benefits when you say you can't do that job anymore. You may be in a situation where you have to go to court in order to get workers' compensation benefits. And in Georgia, the difficult thing about that situation is that you may be able to prove your case in court, but it can take quite a while to get to court. It can take months, and if you deal with appeals after a hearing, it can take even more than a year before you have a final decision from a judge. That can be difficult for a lot of people because they can't wait that long without money coming in to pay their bills. And if they're unable to work as a result of their injury, they may not be able to go back to work doing something else. So that's something that you need to think about whenever you're dealing with a light-duty job offer in a workers' compensation case, is what's going to happen if I try to attempt this job and at some point I'm unable to continue doing it, and how's that going to affect my right to continue benefits? You need to be thinking about that when you're making a decision about whether you continue working or whether you go out of work. Hope you found this information about light-duty job offers and what happens if you're unable to continue doing the light-duty job helpful. If you have, please let me know that by giving this video a thumbs up or by liking it. If you want more information about light-duty jobs or any other part of workers' compensation law, I'd encourage you to visit our Perkins Studdard Workers' Compensation YouTube channel. All the videos from the Georgia Workers' Compensation video series are available there, and you can subscribe to be notified of future videos as they come out. If you've got some specific questions about your workers' compensation case, I'd recommend getting a free consultation with a workers' compensation attorney. If you'd like to set up one with me, I'd be happy to do that, and there's 2 easy ways you can do so. First is by calling the phone number at the bottom of the screen, or the second is by visiting our website, www.perkinslawtalk.com, and completing and submitting our free consultation request form. Thanks again for watching this video today. I want to wish you the best of luck as you recover from your injury.